Hello everyone, and welcome back after the break. I hope we have had a nice lunch, a fulfilling one, and not too heavy. No rajma chawals here, right? So we got to be awake for the next session. Hello everyone. Welcome back. Let's give others a couple of minutes to join, and then we'll begin our discussion for the day. For the afternoon rather. We'll have a small break at around 3:30, and then a tea break at 5. Shalu, yes, the line is very clear. The government can provide reservation in MEI Supreme Court judgment. So if your doubt is but Article 15 says it cannot, Article 15 does not say it cannot. Article 15 leaves MEIs out of mandatory reservation. In future, it could have been. So Supreme Court has said that the state can provide for reservation in MEIs which are aided. Okay. Great. So now let's move on to right to property. What is right to property? The right you have to, which you have to acquire, to hold, keep, and to dispose, sell property. That's right to property. So of course we have right to property. Article 19(1)(f) was a part of the Constitution at the very onset. Apart from it, there are two other articles in the Constitution which were a part of right to property. Article 31. This Article 31's first clause actually said that no person shall be deprived of his property except or save by authority of law. So Article 19 is meant only for citizens, to just be clear here. Citizens. But if you observe, this is meant for people, everybody. That no person shall be deprived of his property save by authority of law. Now, as far as the second clause is concerned, so first clause is very clear that no person shall be deprived of their property, but a law can be made to take away your property. That is allowed. Second clause says that no property shall be compulsorily acquired or requisitioned save for a public purpose, meaning except. So your property can be acquired compulsorily also, but for a public purpose. Let's say the government wants to build a bridge, lay down railway tracks, constructing dams, mining, etc. In those cases, your property can be taken away, but a law is required, and You will also be given an amount by the government in lieu of the property, but such amount shall not be called into question in any court that this amount is very small. So whatever the government takes from you, they'll give you an amount in return. Let's say government takes away 10 acres land from you. They'll give you, say, 100 rupees in return and say, come on, enjoy, go eat one dairy milk chocolate. That will not be the case, of course. But if they do, can you question this particular thing in court? You cannot. But Supreme Court has actually modified this, and Supreme Court has said that any amount will not be justified. You have to give an amount which is in proportion to land value. And we know very well, when the government takes land, they give a lot of money in return for the land. So that is never going to be a problem. These three are right to property available at the onset of our independence, the Constitution. But if you remember, we were discussing about Article 13. So I said that, all these government also had a policy of what? Land reform. So government said, let's play Robin Hood. Let's take land from rich people and give to poor people. But if you take my land, I will immediately take you to court, because I have a right to dispose of my land. Who are you to take my land? And this is a fundamental right, and no law can be made to take away fundamental rights. That's not possible. But then the government said, we are not making a law. What are we doing? We are amending the Constitution. So this is not a law, but amendment to the Indian Constitution. So this was the first Amendment Act 1951, which added Article 31A. This article said that state can make laws to acquire large estate. Large estate means property. So this article actually gave the state the power to make laws to take over land. Article 13 said you can't make a law, but we amended the Constitution and said that but state can make laws to take away property. And number two, when the state makes any such law to take away property, that will not be questioned on grounds of violation of fundamental rights. So basically, you cannot question that law just because it violates some fundamental rights. Clear on this? Apart from it, the center also created a very unique situation. It, with the same Amendment Act, added one more article and also added one schedule called Schedule 9. This is Schedule 9. Okay. So now we are discussing Schedule 9. So far we have discussed 10 such schedules. This is the 11th such schedule. One schedule is left. So just to quickly recap everything: Schedule 1, names of states and UTs. Schedule 2, what is Schedule 2? Schedule 2 deals with salaries and emoluments. Schedule 3 is with respect to oaths and affirmations. Schedule 4, what is Schedule 4? The allocation of seats in Council of State. Schedule 5, administration of scheduled areas in 10 states. Schedule 6, tribal areas in 4 states. Schedule 7, list. Schedule 8, we have not studied. Schedule 9 is this. 10 is anti-defection law. 11 is the 29 items on which panchayats can make laws. And 12 is the 18 items on which municipalities can make laws. Now, Parliament said that we are creating a schedule, and that schedule is going to be one where just a sec, guys. And that schedule is going to be one in which we'll make a law and we'll place a law. If I pass any kind of law, and if I put this law in this box, which I am calling Schedule 9, judiciary cannot question that law. What can that law be? Anything. If I make a law, Killing All the People of India Act 1952, and I place the law in that schedule, judiciary cannot question it. Very weird, right? I mean, you are giving yourself such a wide power that I can make any kind of law, whether right or wrong. But if I place that law in Schedule 9, Judiciary will not be able to question this law only. You are taking away the power of judicial review. So this matter had actually been challenged in the court that this is not justified. It violates Article 14 because now the parliament can make any kind of random crazy law, right? Irrational law, unjust law, unfair law, and then it can simply place the law under Schedule 9 and then nobody questions it. So the point to be understood here was the parliament had taken this right of judicial review away from the courts. Now, after basic structure doctrine in 1980, especially in the Minerva Mills case, when Supreme Court laid stress on the importance of judicial review, then it was being said very clearly that if judiciary has the power to review, then can it not review Schedule 9? This matter dragged on and finally in 2007, an IR Coelho case resulted in the judgment where Supreme Court said that, see, Parliament, you have made Schedule 9, no problem. You are placing laws in Schedule 9, no problem. We will not check those laws, no problem. But if any law you place in Schedule 9 violates basic structure, then we'll question it. Are you clear? So any law that you make and place under Schedule 9 will no longer have the immunity of judicial review subject to basic structure. So basic structure cannot be compromised. That is why all the laws added in Schedule 9 from this date, they can be questioned in the judiciary if they violate BSD. What is this? Basic structure doctrine. Okay. So now also Schedule 9 is there. Now also laws can be placed there. But the advantage of Schedule 9 is that you cannot question laws placed in Schedule 9 on the ground of violation of basic structure. On other grounds, you can question the law, but not on the grounds of violating basic structure doctrine. This is IR Coelho case 2007. Okay. This is what summarizes Schedule 9 now. So now we know Schedule 9. The Schedule 9 is there. You can place laws. They can't be questioned on other grounds. But if they violate basic structure, then they can be questioned and can be cancelled also, because basic structure can never be modified. Okay. Lastly, during emergency, or in fact just before that, Indira Gandhi also made one more change. See, the idea in our country has always been welfare politics. Welfare. And we'll be studying DPSPs shortly. The next topic is DPSPs only after rights. And you will see that DPSP is all about welfare of people. And there are two very unique provisions in DPSP which are hardcore welfare topics. I'll just show you the articles. I'll explain first. These two articles say that it shall be the duty of the state to make such policies that will result in the ownership and control of country's resources, water resource, land resource, mineral resource, whatever resources are there in the country. We will make such laws, and laws should be made in such a fashion, or policies should be made in such a fashion that all these resources are distributed for everybody's benefit, not only for few people. The state shall in particular direct its policy towards securing that the ownership control of the material resources of the community are so distributed to serve the good for everybody. The country's resources will be there to benefit everyone. Not just this, the state should make such kind of economic policies that it should not result in the concentration of wealth in the hands of few people. So my policy should be in such a fashion that it should be distributive wealth. It should not result in rich getting richer, poor becoming poorer. Now, Indira Gandhi said that whatever policy I make, you guys always go to court saying Article 14 violated, Article 19 violated, government is interfering in my property. What to do? I am completely suffering from this. So, she modified the constitution once again and now says we will have an Article 31C, third article added. With this provision, she said that any law that the parliament makes which tries to give effect to 39B, 39C. These are two 39B and C, 39B, 39C. If I make any law trying to distribute countries' resources amongst everyone, land from rich to poor, or I try to make policies to favor the poor people, you will not be able to question that on grounds of violating Article 14 and Article 19. Meaning, if I make a law to provide for welfare of the poor against the rich, you can't question that law just because it violates Article 14 or 19. This showcases that the interest of the country is always aligned towards welfare. Now, whether it has happened or not, that is a secondary discussion. But this is what is there. And this has been accepted by Supreme Court also as valid. So don't feel that Article 14 and 19 are very sacred and all. They're not very sacred. If the larger good of the country is involved, then Article 14 and 19 can be violated also. Okay? So this is with respect to Article 31C. Now, in 1976, Indira Gandhi said, not just 39B and C. If I try to give effect to any DPSP article, any DPSP, so you don't know DPSP right now, DPSP has various articles. Some of the provisions are completely absurd and some are very, very abstract provisions. So this is too much. Very vague provisions are there. So just to give effect to some random or vague provision, I can't violate 14 and 19. But Parliament said, but Indira Gandhi said, no. If I have to achieve some DPSP, I can violate 14 and 19. Now this means that there is no 14 and 19. For everything you can violate 14 and 19, then what's the point of 14 and 19? So Supreme Court cancelled that change. It said this change is okay, but that change is not okay. Expanding the scope of Article 31C to all DPSP, that is not okay. Because 39B and C talk about distributing countries' resources to everyone and also reducing the concentration of wealth. That we are okay. But not a generic kind of thing that for any DPSP you can violate Article 14, you can violate Article 19. Then what's the value of 14 and 19? Anyway, during emergency, Indira Gandhi had also added 131D, saying that if I make any kind of law to prevent anti-national activity, that law cannot be questioned. This is just to give more power to itself, that I can make any law and I'll say this is law to prevent anti-national activity. Don't criticize me. Why? It is anti-national. So you can make any stupid law and say don't criticize me, anti-national, and we can't question it. That is wrong. Anyway, that article was repealed also in 1977. So nothing much to understand there. That was gone. But when all these things were done and the basic structure doctrine was incorporated, then what happened? Then Janata Party came to by 1978. And Janata Party said the whole problem of this boils down to the right to property articles only. They are always causing a concern when we try to have progressive steps for the poor people. So Janata Party, through the 1978 amendment, made one change, and this was the change. Janata Party simply said, repeal this article only. This article gone. Fundamental right repealed. Number two, this 31 clause 2 repealed. This was the same article which said that compulsory property or compulsory acquisition will take place through a law only and for a public purpose only, and for that an amount will be given to you. right, which you can't question in court, and court had said, no, you can question it. Those two were repealed. And one Article 31(1), which said that no person shall be deprived of his property save by authority of law. This was retained. But think of this. Repealed, stays, but not in fundamental rights. What we did was, this is the constitution, and this is the small part that we call part 3, which you refer to as fundamental rights. Yes or no? Here we have Article 31(1). We took this article out of rights and threw it somewhere else in the constitution, Article 300A. So we took the article out of fundamental rights and made it a constitutional right. Are we clear on this? We took the article out of fundamental and made it a simple constitutional right. These three changes were made in 1978 to right to property. Solve this question quickly. 30 seconds, not more, not less. Mark your answer, please. Quite a mixed bag of answers, but anyway, what is the position of right to property in India right now? So, right to property, is it a fundamental right? Of course, it is not. Right? Neither fundamental nor legal. Really? But right to property is currently a constitutional right. Constitutional or constitution is also a law. If you remember the very first photograph we had drawn, inside all the laws, we have the constitution. So, constitutional right is also a legal right. So, this is also wrong. So, yes, it's a legal right, of course. Available to whom? Citizens or any person? Let's see Article 31, Clause 1. No person. So, Article 31, Clause 1, which says no person, Article 31, Clause 1, which is now what? Article 300, capital A, talks about person, not citizen. So, B is the right answer and not A. I hope this point is clear to everybody. Okay. So that is all as far as right to property is concerned. Yes, Shalu, 19(1)(f), what have I mentioned here? Repealed. What is the meaning of repeal? To remove. So it is not there in the constitution. Now coming to the last fundamental right, which is in the words of Ambedkar. So Dr. Ambedkar responded in the Constituent Assembly when nobody asked him, but he said on his own. He said that Ambedkar is mentioning the statement. I am quoting Ambedkar. He says, if I was asked to name any particular article in this constitution as the most important, an article without which the entire constitution would be a nullity, I could not refer to any other article except this one. And then he goes on to say, it is the very soul of the constitution, the very heart of it. soul of constitution, heart of constitution. Because you have all these fundamental rights that you enjoy, that I enjoy, everyone collectively enjoys, but what if they are violated? What can you do? Go to court. Where is it mentioned? Here. This article says that you can go to court if your rights are violated. Now, some basic information. First up, Article 32 talks about right to constitutional remedies. Right to constitutional remedy. Supreme Court can issue writs. What are writs? We have discussed this word writ. Writ means order. Writ means directive. So Supreme Court can issue writs, meaning orders or directives for protecting fundamental rights. Of course, High Courts also. Supreme Court can do it under Article 32. High Courts can do it under Article 226. Small difference. Supreme Court can issue writs to protect fundamental rights. Fair enough. High Courts can issue writs to protect fundamental rights and on other matters also. But Supreme Court cannot issue writs under Article 32 for other matters. For other matters, you have to firstly go to High Court, then appeal in Supreme Court. So that is why we say that we can directly go to Supreme Court to get our fundamental rights protected directly. Not only because we can go to High Courts also, but we can directly go to Supreme Court. But there is a small point to be noted here. In 1987, there was a case called P.N. Kumar case. In this case, Supreme Court said that when it comes to the Supreme Court, you have to, you can approach the court directly, but please don't directly come to the Supreme Court. Okay. Don't directly jump to Supreme Court, go to High Court first. That is why you will find that even though to protect your fundamental rights, you can go to Supreme Court. Supreme Court will not allow the petition in most cases. It will say approach High Court first. What's the problem? High Court is also a court of records. It also has a complete power to issue writs to protect the fundamental rights. Go to High Courts first. Don't come here. So yes, we know very well you can directly go to Supreme Court, but in reality, this may not work because Supreme Court has said in P.N. Kumar case that go to High Court first. Don't come here. You have one avenue, approach them. If you're not happy, come to us. And Article 139 also says that if we want to increase the writ jurisdiction of Supreme Court, if we want that the Supreme Court should be given the power to issue orders on other matters also, then what we can do is Parliament can make a law and increase that power. So of course, Parliament can increase the power of Supreme Court. Now, what kind of writs are available in the country? So number one is habeas corpus. What is habeas corpus? I'll explain through an example. See, as far as habeas corpus is concerned, one very important element that you need to understand for habeas corpus is the meaning of what it actually is and how is it used. So, just to remind you of our movies of 1970s, 80s. For those who have seen those movies, you would know, and for those who have not, I'll tell you. The movies largely had a similar context and a concept where the hero belonged to a poor family. The heroine belonged to a very rich family, and the hero is an amazing person. Like he's uh, a dashing young man, good in sports, topper of college, sings, dance, plays guitar, everything. Master of all the trades. But somehow is not able to get a job because of his attitude problem. But then he falls in love. Always with a rich person's daughter. Always. And then rather than searching for jobs here and there, he goes to park and starts singing songs with this girl. And when they are singing songs, the heroine's father is crossing that park and he sees them singing songs, becomes very angry and upset. Goes back home, waits for the daughter. Daughter comes back home, singing, smiling, giggling, as you do in love. And then what happens? The father becomes angry, catches the daughter, takes her to her room, throws her on the bed, and locks the door. And then the girl falls on the bed, starts crying and all, right? In this situation, what will the hero do? Hero starts crying, singing sad songs, etc. That's the problem. The hero should have directly gone to High Court and filed a writ of habeas corpus. So if hero would have attended the UPSC classes, he would know. Or if hero had read the constitution, he would know that this is an opportunity that he has. Go to High Court and tell the High Court that, my lord, this girl's life and liberty has been violated. She is being held against her will. When you go to the High Court or Supreme Court to get this, you are securing the release of person to secure release of person from illegal detention. From illegal detention. And courts will not seek facts also. Court will not ask, what's your problem? Who are you? No. Usually, courts don't seek facts. And it can be secured as a matter of right, meaning what? Court will not refuse because somebody's life or liberty is under threat. The court will immediately issue an order to the parent, to the father, saying, come on, bring the girl in the court. Later on, when the girl comes in court, she can tell the hero, who are you? That is secondary. But the girl has to be called in the court, body has to be presented. Okay? So next time anything like this happens to any of you here, whether male or female, this is what you can do. Approach the court. Now, later on, whether that guy or girl refuses to accept or recognize you, that's up to you. But I have given you the idea on how to use the legal system to your advantage. Okay? Now, this is what is called habeas corpus. This is something which can be used against private individuals, also public authorities. Meaning, if police has arrested somebody illegally, you can go to court. The court will give the order, police, present the person. Will ask reasons, why have you arrested the person? And when the police says, no sir, it is under preventive detention or whatever, then the court will say it's okay. Or the court can say, release the person, right? So this is what is called habeas corpus and this is how it is used. I hope this point is clear. And let's say, so just to also add to this point, let's say you go to court and whatever case, the person you love, and the person you love says, who are you? They refuse to recognize you, saying that, no, I am happy with my father. Don't worry, court will not punish you. The court may scold you, but nothing happens to you. Court understands all these things. But if you constantly do the same thing again and again, next month you go to court again for a different person, third month for a different person, then the court may impose penalty on you. But otherwise, nothing happens. It's okay. No problem. Are we clear on this? This is called habeas corpus. No need of any locus. Shalu, no need of locus standi also. It makes no sense. If locus standi is asked, then it will make no sense here. Anyway, if you are securing release of somebody, Article 21 is getting violated. This is like a PIL. So no problem. Then I will try. But try at your own risk and all. Please don't come and tell me, sir, see what happened. Our relationship also came to an end. So please, when you are going against somebody's parents, please understand that the future is very bleak. Eventually, you have to live with those parents also. This is habeas corpus. It can be used against public authorities, also private individuals, anyone. Next is mandamus. Mandamus means to command. When you go to a government office and you find the government official sitting in the table playing solitaire, Candy Crush, surfing Instagram, YouTube shorts, not doing his work, what do? You can do nothing. Some states allow you to go to Lokpal and complain, Lokayukt and complain, but most states don't. So what do? How do you ask the person to perform his duties? Court. What you'll do? Go to court. Right? The point is, if any public official, any court, they fail to perform their duties, you can approach the court, ask the court that, sir, my lord, they are not performing their duties. Issue a writ, order, directive of mandamus. Then the court may issue. Firstly, this is not mandatory. Not mandatory for courts to issue order. Okay. Courts can refuse it, saying, what is your problem? You say, sir, that person, when I go on the to that particular seat, he is the RTO is not giving me a driving license. The court said, did you pass the driving license test? You say, no, sir, I failed. Get lost. So, of course, the point being that you have to have a genuine case there. Apart from this, the court will also ask the concerned people there on what is going wrong. Simple example. Let us say you go to court saying that, sir, in my colony, the police patrolling van does not patrol the area, making my area more unsafe. Now the court can ask the police, what is this? Why don't you patrol the area? The police can simply say, sir, that my lords, that area is very safe. No crimes are committed there. We are overburdened with supervising other areas, or maybe for the next 10 days, some function is going on in some other area. We are busy there. We can't do it. So there can be hundreds of things that can be a problem in the government sector. Let's say you want your work to be done, but staff is absent. You can't get a mandamus issued. That's not possible. You have to understand the challenges of the particular organization also. There are only 2 staff, and you say, no, I want my work done. You have to wait. As simple as that. That is why mandamus is something which you cannot claim as a matter of right compared to habeas corpus. Clear? Also, mandamus cannot be issued against the president or the governor. Otherwise, what will happen? You will go to court and say, court, ask the president, sign the bill. Then what's the point of pocket veto? It makes no sense. So you can't get it issued against the president or the governor. Also, plus legislature. Legislature to pass any bill. Meaning, again, it will be very silly. You go to court and say, court, issue order to parliament to pass this bill immediately. That's not possible. The bills are passed based on the discussions and approval of the House. Court has no say in all these things. Now, if you go and ask your father for a mobile phone and your father says, get lost, can you go to court? Asking court, mandamus to my father, I want mobile phone. Of course not. This is not meant for private individuals. But if a private individual is performing public function, then for that function it can be issued. For example, if I am given the public function, I hold a government contract to build a road and I am not building a road, you can go to the court and get an order against me forcing me into constructing the road, because that is a public function. So, plus private individuals also if performing public function. Okay. That was mandamus, habeas corpus, mandamus. Now, two writs are very close to each other. They are just an extension of each other. Imagine this case that takes place in our country. Let's say this is Article 21. Article 21 and the interpretation of Article 21. Article 21 can mean hundreds of things. Hundreds of things. And the courts we have seen keep on widening the scope of Article 21. Let's assume that the courts you'll be surprised at the kind of things people go to court for Article 21. A few years back, there was this case where somebody went to court saying, sir, I'm tired of my job. I work from 9 to 5, 6, 6:30, 7 o'clock. And when I come back home, I'm tired, exhausted mentally. And when I pour myself some drinks, I drink a couple of pegs of whiskey, I feel relaxed. I forget all the worldly problems and I'm more calm. Please, under Article 21, also expand it, right to drink, right to forget all the worldly problems. Court said, leave immediately. Now, these things are also there that people go to court for, of course. But let's assume you are somebody who loves to smoke ganja, right? And I don't know, maybe you are, maybe somebody's. And you say that, sir, when I smoke ganja, so go to Amsterdam, go to Canada, go to Thailand, all these countries allow, they have legalized marijuana. What is this? My brain starts functioning. I remember all the articles properly. I can solve all CSAT questions properly if I smoke ganja. Right to clear examination, right to full use of brain under Article 21. Please interpret it. Now, but because you have completely lost your mind, you go and file this case in the lower court, trial court, subordinate court. You should know very well that subordinate courts don't have such writ powers, number one. Number two, subordinate courts cannot interpret the constitution. They have no right to interpret the constitution. Interpreting constitution is the task of High Court and Supreme Court. So what you have done is you have filed a case in front of a wrong court. Wrong in the sense the court has no power only. What can it do? So when you file such a case in front of a wrong court, the higher court, High Court in this case, can issue a writ order of prohibition, prohibiting the lower court. Lower court, how dare you take up the case? Don't take the case. So I, as a High Court, will order the lower court, stop. How dare you take this case? This is beyond your jurisdiction. Don't take this case. Prohibiting the lower court. Clear? It is issued against a lower court about to commence proceedings in a case over which it has no jurisdiction. Okay? It prevents lower court from usurping, capturing, taking over jurisdiction with which it is not vested, not given. So lower court was not vested with the power of interpreting Article 21. So of course it cannot interpret Article 21. That would be wrong. Higher court will immediately stop the lower court. That lower court, please, sorry, you can't take up this case. This is called prohibition. It is preventive in nature. Why preventive in nature? Because it prevents the lower court from committing a wrong. That is why preventive in nature. Now, when the case is filed in the lower court, what if the judge there is very excited? He says, oh, you have come to file a case, Article 21. I am getting a chance to interpret Constitution. Come on. And he accepts the case. Right? What if the judge accepts the case? Case has been accepted and trial begins. The judge says, yes, come on, tell me, what are the advantages? Yes, you lawyer, tell me, what are the problems? And trial has started. Now suddenly the lower court is hearing a matter which is beyond its capacity only. Then what happens? The lower court has commenced, begun proceedings. Trial has begun, which is not allowed. So the higher court will tell the lower court, wait. Give this case to me. You have no power on this case. Come on, transfer it to me. Useless fellow. And transferred. Certiorari. This is to certify that you are not fit to hear this case. This is beyond your jurisdiction. Transfer the case to me. The higher court will order the lower court to transfer the case to itself. A preventive thing, which again prevents the lower court from taking up a matter or discussing a matter which is beyond its jurisdiction. But imagine if the judge is very excited, and judge is also like you. He also loves to smoke ganja. And judge, when you file a case, judge says, oh, I was waiting for somebody to file a petition like this. Come on, judgment approved. From today onwards, under Article 21, you have a right to smoke ganja. And you guys start smoking there only. Now, the judge here has passed a verdict on a topic over which he had or she had no power. They have actually passed a verdict only. No power. This is a classic case of certiorari. Higher court will say, firstly, higher court will cancel the lower court order. See, whether order is right or wrong is secondary. The point is the lower court did not have the authority of passing such an order, mind you. Were you authorized? Not authorized. So, you have passed an order. We have to cancel the order first and then transfer the case to me. Higher court can quash, cancel. Quash means cancel the order, verdict, and transfer the case to itself. So here we say it is more curative in nature. What is curative? When you are curing a wrong done by the lower court. Because lower court did not have the authority to pass such an order. Certiorari. So prohibition and certiorari are both largely similar in nature in the court system. It is just that certiorari is an extension of what? Prohibition. Now, last writ is the writ of quo warranto. What is quo warranto? Very simple. For every public post, there is some eligibility criteria. Eligibility criteria. For example, if you want to contest elections, you have to be a citizen of India. For MP or MLA post, MP Rajya Sabha, MP Lok Sabha or MLA, age 25 years. MP Rajya Sabha, MLC, age 30 years. Let us say the best example is the case of Mr. Rahul Gandhi. Every time he contests elections, somebody goes to court saying, sir, Rahul Gandhi is not an Indian citizen. You issue an order. Ask him to prove that he is Indian citizen. Arey bhai, he is an Indian citizen. He has been contesting for so long. Don't file all these stupid cases. But people do. Why? It challenges the claim of a person occupying public office. Basically, we are checking the eligibility. Are you eligible to hold that public post or not? Okay. Are you eligible to hold the public post or not? You go to court. If the court finds that no, you're not eligible, then the court can also cancel your what? Cancel your post, remove you from post. This is what is quo warranto. Asking you by what authority are you holding the post. So to give you a better example from your own personal life, let us say you do not follow any guidelines, don't study properly, waste your time here and there, right? Enjoying life fully. And finally, you reach the age of 32. You're a general category student. Attempts, age limit is over. Now you are sad. You are very sad. But the point is, some friend comes to you and says that, listen, don't be sad. What we can do is I will get you a fake certificate, OBC certificate, and your age will increase or whatever. Then you can take the exam again. You say, okay. And your friend gets you an OBC certificate, whatever. Now, this time you know this is your last attempt, you are very serious, you study properly, revise, mock test, answer writing, and you clear the examination. Raj Sabha TV, Z News, NDTV, all have come to your house. And you are now giving grand interviews. And you know, this was very easy for me. I hardly studied. All that nonsense that toppers will say. All this is happening, but your neighbor is watching everything. And neighbor is sad that you have cleared the examination. And neighbor is wondering, how did you clear the examination? More so, neighbor thinks, how did you, I mean, are you still 32? See, neighbor has every information. That's the duty of neighbor, right? To keep information about you, where you are smoking, with whom you are roaming around. That's why they inform your parents about all these things. That's their duty, to inform your parents. So here the neighbor takes out his record that he has maintained about you, says, no, this person was born in 1990, now it is 1924, 2024, he is 34 years old. Sorry, he cannot take the examination. Some problem. He goes to court, files the petition. Sir, ask him. Order, issue a writ of quo warranto. Ask him to prove his documents. And if it is found that your documents are false, then you'll be removed from the post. This is how quo warranto works. Are you clear? Anybody can approach these courts with respect to these writs. There is no need to have any locus standi and all. This is upholding and protecting rights of people. You can approach the court whether you are at party or not. Any person can approach the court to get those writs issued. Okay. Moving on. Before that, solve a question first, which came in the exam last year only. I'll give you a minute, read it properly, and then solve it. %61 got this answer correct. Let's see. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Of course, it is correct. No problem. Mandamus will not lie against a company even though it's a government company. Come on. If it's a government company, mandamus is available against it. So 2 is wrong. Remove 2. Remove this. Remove this. Remove this. You have the answer only. No problem. Any public-minded person can be a petitioner to move to the court to obtain the writ. Of course, anyone can approach the court for quo warranto or any other writ also, no problem. Okay, so C 1 and 3 only are correct. Now we are done with our rights. Couple of other things to know. Very simple. Ravi, sir, for any habeas corpus or mandamus, can I approach district court or only high court? Habeas corpus is up to be filed in Supreme Court and High Courts only, lower courts. You can approach the lower court to get a writ issued, an order issued, but for habeas corpus, High Court and Supreme Court, because it allows for the protection of Article 21, right? Sudhanshu addressed. Okay. What else do we have? Let's see first. It's very difficult to remember 32nd article. I think it's very easy. Okay, Article 32, Gulam says we need one more revision. I'll just quickly revise. Habeas corpus, see, if you go through it just once, it is impossible. Read it 10-15 times. That's the power of revision. Habeas corpus, meaning what? Issued, remember the example of hero going to court. You'll be clear on this. Protecting Article 21. Mandamus, ordering a public official to perform his duty. Prohibition, asking lower court to not take up a case. Certiorari, asking lower court to transfer a case or cancelling the judgment and transferring case. And quo warranto, checking the eligibility of any person holding a public office. Okay. Okay, so that is there with respect to our writs and fundamental rights. Now, Article 33. What is Article 33? Article 33 simply says that Parliament can modify the application of fundamental rights on certain categories of people. Okay. Plus, such laws can't be challenged also. So in our country, we have a lot of these situations where people are employed in not some regular activity, but activities which involve protecting the sovereignty of the country, the integrity, the security of the country. Now you have a right to sleep. Okay. Let's say some senior military officer commands its battalion, the platoon, come on, attack. Officers and all the people say, sir, right to sleep, Article 21. I will sleep right now. And they start sleeping. It makes no sense. You have to understand that all these rights that others enjoy, in some services, you will not be allowed to enjoy all those rights. So we have certain laws like Army Act, like Navy Act, like Air Force Act, like Police Force Restriction of Rights Act. These laws prevent the enjoyment of rights on officers under these laws. So rights, fundamental rights can be modified in their application, of course, to ensure a sense of discipline, etc. For example, you can criticize, if you say go to any company, government company also, you can criticize the quality. Let's say you join Labasna. You go to Labasna, you record a video and upload on the Facebook, Instagram, whatever, that what kind of food is this? Very bad. That's, still justified. But if a BSF Jawan does it, it demoralizes the entire troop, entire force. They can't be doing all this thing. They can criticize the army. So your freedom of speech and expression can be restricted. So fundamental rights can be restricted when applied to certain categories of people. And this is a true story of one BSF Jawan who posted a video on the poor quality of food being given, and he was removed from service later on. He then wanted to contest elections against Narendra Modi from Varanasi, could not contest also. Anyway, Article 34. Article 34 is a very interesting concept of what we know as military rule, martial law. What is martial law? Martial law refers to military rule. So, in our country, if martial law is in force, then fundamental rights can be suspended. Okay. Fundamental rights can be suspended. Now, we don't know anything else about martial law because there is no rule, no regulation. I am repeating this and please understand. There is no rule, no regulation, no law whatsoever on martial law, no guidelines anywhere mentioned. So we don't exactly know what will happen in case of martial law. I'll just give a basic example on basic understanding because martial law was applied by Britishers in the Sepoy Mutiny, as they used to call the War of Independence, or in the case of Pacha Rebellion in Cuttack, 1817-1818. So Britishers have imposed martial law, but in independent India, this has never been imposed. So what basically happens is, let's say this is a state. In this state, there is a small area. In this area, there has been complete breakdown of law and order. Complete breakdown. And the local police is unable to handle this breakdown of law and order. Law and order breakdown. Local police is simply unable to handle the breakdown of law and order. So for a temporary period, what we'll do is suspend all the local authorities, no SP, no DM, no government. We'll send military to this area, give this area, the control of this area to the military and tell military, restore law and order. For that area, for a small period of time, military rules, okay, and ordinary government, ordinary law courts are suspended. Your rights may be suspended. Once the law and order is restored back, then the military can be called back and the regular government is restored. So it does not really affect the center-state relation, no problem there, just for a small area. And it only exists in a small area, imposed in some specific area of the country. And there are no guidelines for this, no provisions for this. It is just in the implied sense. It is implied that this might happen. That is all we know as far as martial law is concerned. Nothing more, nothing less. No, Priyanka, AFSPA is different. AFSPA relates to disturbed areas. Regular government is not suspended there. It still functions there. The Armed Forces Special Powers Act. So AFSPA is different. Martial law is different. Martial law suspends the regular things. Only army, nothing else in that area. Okay, this is Article 34. And lastly, Article 35. So we have seen in some places that the state can make laws to provide for certain things. In those places, only parliament can make a law and not the state legislature. Number one, punishment for traffic in human beings. Who can make a law? Only parliament can make a law, states cannot. Number two, punishment for untouchability. Who can make a law? Only center can make a law, states cannot. Article 34, martial law. Who can make a law? Only center. Article 33, modifying application of rights on certain people. Who can make a law? Only center. Empowering other courts to issue writs. Who can make a law? Only center. So as parliament can make a law and give this writ issuing power to other courts also. And Article 16, residence as a criteria for reservation or employment. Who can make a law? Center can make a law, states cannot make a law. These are those areas where only the parliament can make a law and states cannot make a law. Sir, how can we remember in which case who can make a law? Namita, how innocent. You have to mug it up. What to do? It's very easy. It's not that difficult. See, If you read something for the first time, you will find it difficult, of course. So, revisions. And again, these are very intricate questions. UPSC asking a question like this is slightly unlikely. You have seen the type of questions they're asking. We are studying so many things and they're asking, right to privacy is under which article? Come on. It insults the intelligence of people like you, the UPSC aspirants. But anyway, these are the 5 things, that's it. Or 6 things, sorry, that's it, nothing else. Only in these situations will the parliament only be allowed to make laws, not the state legislature. So very simple. Mark these up. In all other cases, both can make laws. Okay. Now, suspension of fundamental rights. We know this, Article 358, Article 19 is automatically suspended, and 359, rights, that is the right to move to court can be suspended for under Article 359 except 20 and 21, right? Now we are done with fundamental rights. Let's summarize by looking at the nature of fundamental rights. First things first, most of them are available against the state, right? State shall not discriminate. State will not do this. State will not take away property. Some are available against people also. Article 17. State cannot practice untouchability, people can. State can exploit, people cannot. No one can employ kids. So some rights are available against the state, others against other people. Most rights are negative obligation, meaning what? State, don't do this. State, don't do that. State, don't differentiate. State, don't discriminate. Some rights are positive obligations. A very good example is Article 21 capital A. What is this? A positive obligation. State, do this. Provide schools and colleges. Provide for right to education. So negative meaning placing limitation on state. Positive meaning asking state to do something. Then some rights are self-executory. Freedom of speech and expression. The moment this right is given to you, you can start talking nonsense from the very moment, right? No need to pass a separate law. But sometimes some other rights require some law. Like Article 17, we are saying untouchability is banned. It is punishable. But where is the punishment? Law is made called PCRA. Article 21A, go to school and college, study. But where? How? What is the procedure? We make a law called Right of Children to Free and Compulsory Education, RTE Act. Then all fundamental rights are justiciable. What is the meaning of justiciable? What is this phrase? Justiciable. Can go to court to claim it. That is called justiciable. And I had said in the very beginning, rights are not absolute. Never have this misconception that rights are absolute. No, they are always restricted. Restrictions can be imposed. That is why we say liberty can never be unlimited. Because if liberty means no restraint, it is very stupid. You have to have restraint because your rights also depend on somebody else's rights. They are correlated. Your rights are not independent of society, they depend on others also. I have a right to speak, freedom of speech and expression, but I should not cause defamation. So my right to express myself has a limitation. I cannot defame somebody. Then some rights are available only to citizens: 15, 16, 19, 29, 30. Shalu can go to court for enforcement. Abhinav, this one, Abhinav, what is this concern? Tell me. So these are the fundamental rights. I will not tell you which right is important or which article is important because every article is important. Before you say, sir, How do you expect us to remember all these articles? To which I will tell you, I just don't expect you. I need you to remember these articles because it is important. And when you want the best job in the country, you have to put in the effort also. As simple as that. Free bungalow, deciding national policies, all these things. So, of course, it would require you to put in the effort also. Nobody said it was going to be easy, right? It's not a piece of cake. It requires a lot of discipline and perseverance. So, we need to. More fundamental rights can be suspended during emergency. We know it very well. They can be modified in their application to special services. We know it very well. Article 33. And rights are amendable. So fundamental rights are amendable. They can be amended. They can be deleted. Okay. All these things can be done. Abhinav, is it necessary to make running notes? Running notes are meant for you. If you feel that you want to write something that I'm not writing on the slides, go for it. Now, DPSPs, Directive Principles of State Policy. So, what are these DPSPs? See, as far as the DPSPs are concerned, one very important element you need to understand is that, Shalu, which fundamental rights for part of basic structure? There is no right which is a part of basic structure. Where did you get this information from? The overall underlying essence of rights is a part of basic structure. For example, rule of law is a part. Why same question again? Rule of law is a part of basic structure, but Article 14 is just a small part of rule of law, right? So the underlying essence of rights is basic structure. Rights per se are not a part of basic structure. Difference. The underlying idea behind a right, that is basic structure, but right per se can be modified. Okay. Now, as I said, DPSP. DPSPs in our country govern policies of the country. These are just directives, guidelines. It's not mandatory, guidelines. But these guidelines that you'll see, they decide what kind of policies that the state should make. In fact, DPSPs, if you observe, will also help you evaluate the performance of any party when it comes to power. How many DPSPs has it implemented? Or how far or how effective has it been in implementing DPSPs, or how far has it implemented DPSPs? Because DPSP is all about welfare. This concept that we constantly say that India is a what? Welfare state. So what is this idea of welfare state? When you say India is a welfare state, there is a meaning to it. Welfare state refers to any state which protects and promotes the economic and social well-being of its people. Which protects and promotes economic and social well-being of its people. This is the concept of welfare state. And as far as DPSPs are concerned, they are all about welfare only. See, the concept has been borrowed from Irish constitution. There used to be an Article 45 in the Irish constitution. They call that article as Directive Principles of Social Policy. So we have modified it. We say DPSP, Directive Principles of State Policy. Same kind of concepts are there. welfare state, equal pay for equal work, reducing concentration of wealth. So similar kind of concepts exist in the Irish constitution also. Then originally in the Government of India Act 1935, we had the provision called Instruments of Instructions. Instruction for the government, what kind of policies to incorporate while making laws, how to make laws. Then there's a committee called Sir Tej Bahadur Sapru Committee. Remember Tej Bahadur Sapru, leader of the Liberal Party? So under his chairmanship, the committee gave a report in 1944, I believe. And there, this Tej Bahadur Sapru Committee said that no, we should have two kinds of rights. One will be rights which are justiciable. What is justiciable? We can move to courts. We should also give people some non-justiciable rights, which you can't go to court to claim, but nevertheless are very, very important. Okay. And of course, GOI means Government of India. We have been using this term right from the very second or third class. Government of India. Remember, Government of India, transaction of business rules. Government of India, allocation of business rules. And this is a very standard provision. Government of India Act 1935. Anyway, our DPSPs are classified along three principles. You can understand Gandhian principle based on village economy, self-sufficient economy, etc. Liberal principles, modern, more global, Western ideas, liberal principles. And socialistic, what is socialistic? Socialistic principles are the welfare principles. Welfare of people. Socialism basically refers to a situation where, or a government where the means of production are controlled by the community, or resources of country owned by people. So there is no private property concept. It's everybody's resource. Socialism. More on this later on. Now, definition of the state. We are seeing this. DPSP Part 4, Articles 36 to 51. Part 4, just like you had Part 3. Now, here also directive principle of what policy? State policy. What is state? So Article 36 says state has the same meaning that it has under Article 12. Same meaning. No problem. Now Article 37. Article 37 says that the provisions, and very important article, very, very important article. It showcases the value of DPSP. It says the provisions contained in this part, which part? Part 4, shall not be enforceable by any court. Then what's the point? You will say, then what's the point? I mean, why are we studying this also? And why is it here in the constitution? If provisions are not enforceable in any court, you can't go to court and claim it, then what's the value? But let's read. But the principles therein laid down are nevertheless fundamental in the governance of this country. Mind you, I'm telling you that you can't go to court, no problem. But what is mentioned here is very fundamental to country's governance. And not just this, it shall be the duty of the state to apply these principles in making laws. Any party comes to power, BJP, Congress, DMK, BRS, NPP, whatever party comes to power, those parties, when they come to power, they have to incorporate these principles in making laws. It's their duty to make these principles a part of policies in the country. So this is the importance of DPSP. Though you can't take them to court, but you can actually use this to assess the performance of a government. This is the importance of directive principles of state policy. This is a classification. Now, a question on classification was asked once, but don't mug up the classification. I'll explain to you how to bifurcate. There are some, and these classifications are not mentioned in the constitution. Let me again tell you. Not in the constitution. So, what is done is some principles which talk about equality amongst people, giving resources to people, economic equality, are socialistic principles. These refer to the economic equality plus well-being. Then we have Gandhian principles. These principles refer to what? These are the principles which refer to those ideas of how do you put it? I sorry, ideas of local self-government, ideas of cooperative societies, ideas of village-based economy, self-sufficient economy, all those Gandhian principles. And then we have liberal principles, the more modern intellectual ideas. Modern intellectual ideas. Okay. Like respecting the environment, protecting the wildlife, protecting the national monuments, etc. Coming to the very first article, that is Article 38. So, Article 38 is a very generic article. See, now, let me clarify. When it comes to the DPSPs, there is absolutely, and I say absolutely, no need to know the articles by heart. Okay. We'll see the Gandhian principles. Gandhian principles. Oh, okay. Let me write here. Self-sufficient village economy, Gandhian principle. Self-sufficient, right? Cooperative societies, Gandhian economy. Focus on the rural areas. Focus on rural, Gandhian principle. So anyway, as I was saying, Article 38 is an article, or all these articles that you will see now, there is absolutely no burden, no pressure on you to mug up these articles. Firstly, verbatim, not, I won't say not required. It's not possible. You cannot mug up these articles verbatim. Should you remember it? Yes, you should. At least the basic content of some very important articles, because you can use them in various places in your answers, not just in polity, in social issues, in social justice, in ethics, in essay. So it gives a very nice interlinkage. Imagine if you're writing an ethics paper and suddenly you say, uh, ethically speaking, our constitution, Article 39A, also provides for this. It gives a very nice impact. Oh, see, this fellow has linked multiple topics, right? So that's there. But I'll tell you which articles in general are seen to be important. But let's do one thing. Before we begin this, let's take a quick break. After the break of 10 minutes, we'll come back and we'll look at the DPSPs. Break, please. Break till 3:40. Break, please, guys. Welcome back, guys. Subhash, duty, but at if they don't. Oh, that's why I said that. I mean, see, we'll discuss that later on. That also is a problem. What kind of duty is it? Uh, is it a legal duty or a moral duty? That is slightly vague, but that's how it is. Janvi, state same definition as Article 12. So refer to Article 12. State means parliament, legislature, government of India, government of state, local bodies like panchayats, municipalities, and other authorities as per Ajay Hasia. Fundamental rights are not basic structure, Gulam. The essence of fundamental rights is a part of basic structure. Okay, moving on now to looking at all these DPSPs one by one. First up is Article 38, state to secure a social order for the promotion of welfare of the people. The states shall strive to promote welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all institutions of national life. This phrase is also there in preamble, just to point out. Look at the DPSP. How sweet that the state shall strive to promote welfare of all the people by securing and protecting a social order where there is justice completely, there is social justice, economic justice, political justice. Very nice. But how to implement it? It's very vague. So you'll find that a lot of DPSPs are very, very vague. So making them legally enforceable or making them justiciable could be a problem. For example, the state shall in particular focus, narrow down, in particular strive to minimize inequalities in income. So the state's target should be that inequality of income should be minimized and endeavor to eliminate inequality in status. So there should not be any inequality in status also. Now imagine if this is the case, there should be no inequality in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different avocation. These are the meaning of this is profession. Meaning what? There should be no inequality amongst people residing in different areas. My response is very simple. By if there is no inequality in status and this becomes justiciable, you'll go to court and say, court, come on, issue order to the government. Treat me and Virat Kohli in the same fashion. Why is Virat Kohli's status so high, mine so low? So we may try to remove or reduce inequality. We can't remove it. That is why making all these vague kind of principles justiciable could be a problem. We can't claim these things in court. They are very abstract, very vague. They are some kind of guidelines to be achieved in future. At some point of time in future, there'll be equality, respect, mutual understanding, right? All professions with equal respect. So of course may not be achievable through courts. It will take a long period of time to have that kind of sense. I hope now you understand the concept behind not making it justiciable. Then Article 39 has 6 different clauses: A, B, C, D, E, F. A, the state shall see certain principles of policy to be followed by the state. What kind of policies will the state follow? Number one, the state shall, in particular, very narrow down, in particular, direct its policy towards securing that the citizens, men and women, equally have the right to an adequate means of livelihood. Men and women have equal means of livelihood. Number two, we have seen BNC, that the ownership and control of all the resources of a country should be distributed in such a fashion to subserve the common good of individual. Then clause C, that the operation of our economic system should not result in the concentration of wealth uh, in the hands of few people only, to common detriment. Then D, there should be equal pay for equal work in the country. Then that the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocation unsuited to their age or strength. Look at this. People should not be forced by economic need to get a job. Really? But that's what a job is, right? How many of people in the country are following their passion? It's a dangerous thing. So people work to get money. And you are saying we want a situation where people are not forced by economic needs to work. Is it possible ever? There will be a lot of people who would be employed in a place where they don't want to work, but that's just a source of income for them. You know, we say that there is a group of people who is unhappy with their job. That group is called everybody. So that's the case. Anyway, so again, very abstract principles which largely difficult to get through and difficult to also get obtained by the court system. Then that the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Wait here. Tender age of children not to be abused. Childhood is protected against exploitation. Same thing, different words. It's like a UPSC aspirant. They are saying the same thing. You have 1 point, writing 150 words, same point you're repeating again and again. That's the thing. So these are very basic things. They are just English statements. Frankly, these are statements in English, and I don't think there is anything here to explain hidden meaning. There is no hidden meaning here. It is what it is mentioned here. Flat, simple, as simple as it could be. That health and strength of workers, men and women, are not abused. Nobody is forced to work too much. Nobody is forced to work in any area where they don't want to work, etc. Here also, that children should be given opportunities to develop in a healthy manner. There should be freedom, there should be dignity, no exploitation, etc. So these are just generic principles that should be there in the country. Then 39A. Write quickly. What have we done to achieve 39A? This was added in 1976. Please write. Equal justice and free legal aid. Okay, very good, Dhaval. What we have done to achieve this is NALSA. Remember? National Legal Services Authority, NALSA. So, the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. Okay. And shall in particular. Achha, did you observe a very unique way of phrasing sentences? The DPSP articles start with a very generic language. The state shall secure that the operation of the legal system promotes justice. Okay. And shall in particular. Suddenly, the article becomes very narrow, very focused, that what exactly do they want? And provide free legal aid. This is what they want basically, that there should be some provision of free legal aid by suitable legislation or schemes, like NALSA is a scheme under Legal Service Authorities Act. or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or any other disability. Okay. 40. What have we done for 40? Please write. Organization of village panchayat. Have we modified the constitution? Which amendment? Which year? Okay. 73rd Amendment Act 1992. The Panchayat provisions. So, the state shall take steps to organize village panchayats and endow them, provide them with such powers and functions and authority as may be necessary to enable them to function as units of self-government. Article 40. Then 41. Right to work. Okay. Right to work, right to education. We just saw here that people should get the right to work. 38. Give them work. Here also. Right to adequate means of livelihood. What is the meaning? Adequate, sufficient means of livelihood means what? Right to work only. Again, the same old story, right to work. Repeating the same thing again and again. The state shall, within the limits of its economic capacity and development, should make effective provisions for securing right to work, right to education, and to public assistance in cases of unemployment, old age, sickness, disablement, or any other case of undeserved want. So basically, the idea being that the state should provide for some kind of right to work and other kind of economic help for people who need it. Right? Right to work. So right to work, it's not there for everybody, but it is in the sense of a limited legal right. Yes or no? Limited legal right, what you would know as Narega. Yes or no? Mahatma Gandhi National Rural Employment Guarantee Act, 100 days of paid labor, unskilled labor. That's it. And as far as unemployment is concerned, a lot of states have schemes of unemployment allowance. You get yourself registered there and you'll get some money. Unemployment allowance. How much is that? Not a big amount. But when it comes to unemployment allowance, you can go and claim it. Some 400-500 rupees per year is there. You can drink some juice and all. But yes, the state does provide for unemployment allowance in certain cases. Article 42. Provision for just and humane conditions of work and maternity relief. So the state shall make provision for securing just and humane conditions of work. Look at this. That health and strength of workers are not abused. Same thing. Humane conditions of work. They are changing words, repetitions, lot of repetitions. Same idea. And for maternity relief. So we have a law in the country called Maternity Benefits Act 1961 as amended in 2017, which provides for 26 weeks of paid leave to women who are pregnant for up to 2 kids. Third kid onwards, it's only 12 weeks of paid leave. Why? Because we want to also promote a two-child policy. Then 43, living wage, etc. for workers. Now read this article. The state shall endeavor, take the effort to secure by suitable law or any economic organization or in any other way to all the workers, agricultural workers, industrial workers, or otherwise, work. Again, right to work. I mean, same thing again and again. A living wage, conditions of work, ensuring a decent standard of life. So you have to ensure that they have a decent standard of life. What is the meaning of this? We don't know. And look at this phrase, full enjoyment of leisure period. How do we ensure that? That when you go back home after work, you fully enjoy your leisure period. If you are somebody who is unhappy person only in life, you can never be happy. So how do we ensure that? If you are somebody who is a negative, pessimistic person, you'll always be sad. You can't go to court and say, court, come on, make me enjoy, dance for me. That cannot happen, right? So that is why these words are very vague. Imagine if these things were justiciable in courts. And social and cultural opportunities. And in particular, see, this article here, till here, it is a socialistic article, right? Talks about welfare, economic equality. Suddenly it becomes a Gandhian principle. And in particular, the state shall endeavor to promote cottage industry on an individual or cooperative basis. This becomes Gandhian. Right? Same article can have both elements of socialistic and Gandhian idea. You can see here also, Article 43 is under both these. 43, 43, both. So it's very easy to categorize an article being socialistic or Gandhian or liberal. Then 43A, participation of workers in the management of industries. So state shall take steps by suitable laws to ensure that the participation of workers does take place in the management of undertakings, establishments, or organizations engaged in any industry. So basically, if you look at any, say, banks and all, you'll find that in their board members, there is one person who is also a union member. So the banks have their union. So that union member is also a member of the board. So he represents the interest of people at the board of director level. Then 43B, promotion of cooperative societies. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies also. Then Article 44. Somebody had asked me yesterday, I believe, Article 44. What is Article 44? UCC, Uniform Civil Code. This is Article 44. What is Civil Code? Civil Code means common law governing personal matters. Governing personal matters. Okay, so see, as of now, we have what do you mean by personal matters? Personal matters, for example, would refer to matters like marriage, matters like divorce, matters like inheritance, etc. Okay. And the state shall endeavor take steps to secure citizens a uniform civil code, uniformity, replacing the system of fragmented personal laws into one common law. Okay, so right now this is the situation. Hindus have their own code bill. They are popularly called the Hindu code bills, and in fact the only laws made by the Indian Parliament. The only personal laws made by Indian Parliament are the Hindu laws. That is Hindu Marriage Act, Hindu Succession Act, Hindu Minority and Guardianship Act, Hindu Adoption and Maintenance Act. Then for Muslims, we have two laws, Muslim Personal Law, Shariat Application Act, Dissolution of Muslim Marriage Act. For Christians, we have the Indian Christian Marriage Act. For Parsis, we have the Parsi Marriage and Divorce Act. For Sikh, we have the Anand Marriage Act. Hindus also include Hindus, Sikh, Jain, Buddhists. Okay. Hindus Jains, Sikh, Buddhist, all included. Sikh have a separate law of their own also, Anand Marriage Act. Then, let's not forget, tribals in Schedule 6 areas, remember? They have all these powers, Nagaland, Mizoram, Meghalaya, Tripura, Assam. Then Nagaland separately has its own laws under village councils outside Schedule 6. So many diverse personal laws for different groups in the country. So Article 44 says we have to combine them all together, these fragmented laws, and make a way for uniformity in personal matters. Time for a poll, you know very well. Mark your response. A for yes, B for no. Do you think we should have UCC? How many of you favor one common law for every religion? Mark A. How many of you say no need for UCC? Mark B. No right answer, just choose what you feel like. A for UCC, B for no UCC. Okay. Great. Class divided. Reasons. UCC. All those in favor, please give reasons. No reason so far. Bring uniform means uniformity. Give me an advantage of uniformity. Why do you want uniformity? We live in a secular country. So how is that an advantage? We live in a secular country. That means everybody has a right to practice a religion. Goa has it. So what? Is Goa some kind of standard? And Goa does not have a uniform civil code. Goa has a Portuguese civil code. That's the biggest misconception that we have, that Goa has UCC. Goa has the UCC of Goa is actually a Portuguese civil code, which has lot of issues. So people who are quoting Goa, let me tell you that you are singing praises of Goa. If you are in Goa, let me help you understand. Parents can disinherit their child completely in Goa. Okay, Muslim men, they may not be allowed polygamy. Of course, there is no provision for divorce, but for Hindus, there is a right to bigamy. Hindus can marry up to 2 times if you don't get a child till 25 and you don't get a male child till 30. Are we clear? Where is equality? Uniformity may not always mean equality. Anyway, all should be treated equally. Uniformity in India. Intercaste marriage will be easy. No, it does not make any sense. Intercaste marriage is any which way governed under Hindu laws only. Triple talaq is no longer there only. It is removed. No discrimination. Personal disputes can be solved easily. Same law to govern justice. Social status of female can be uplifted. Okay. UCC has a major challenge because of no. I don't want challenges. I want points in gay marriages can be implemented. How with UCC it can be implemented? Which religion is allowing for homosexuals to marry? The religion that you, Kshitij, I believe the religion you belong to is by far the most open one when it comes to accepting homosexuals. Other religions have draconian punishments of death, stoning, if you are found to be homosexual. Okay. See, couple of things you have mentioned very correctly. Helping improve conditions of women, no discrimination, etc. Treating people equally. I think somebody also made a statement that it will improve easy administration of laws. Fair enough, fair enough. So I see where this is going. The idea being that apart from this idea that there should be uniformity and all, the idea being that there are some problems in the religious laws, which we all agree, we can eliminate them. Fair enough. Let's start with the advantages. Need. Why do we need UCC? See, one very simple argument which should come right in front of every other argument, a logical one, is the simplification of legal system. Simplification of legal system. Okay. Then people also say we have a common civil law. Yes or common criminal law. Why not common personal law? And differences disrupt a sense of social harmony. One common law can foster national and social integration of the country. It will also ensure rights for the marginalized people, for the simple fact that most of these religions have some kind of issues in their personal laws against the marginalized, that may go away. Then securing gender equality, a sense of equality. So, of course, again, women may not face the same kind of discrimination that they will face otherwise. It also prevents sub-national identity. So, when you have different laws and when you are too different from other people in the same society, there could be a skyboxification, meaning the idea being that you create small nations within a large nation. You have an acute sense of group consciousness. This is my religion, my way of life. You are different people. So it uselessly disrupts the social harmony and cohesion in society. And eventually, the judiciary pushes for it because it will ease the task of judiciary. As of now, they have to look into all these laws. But one law, easy task. Imagine you had only one source, one book to study UPSC. So nice. Right now, you have 10, 20 books, so many notes, difficult. So that's the whole point. But then what are the challenges? Tell me. Those who opposed it, mention what is your problem with UCC. So many nice things are happening with UCC. And what is your concern? Tell me. Why so angry with UCC? Diversity. Okay. Diversity gets impacted. Fair enough. Fair. Diversity. Domination of majority religion. Okay. Valid point. Customs are different. Application is complicated. Very nice. Different beliefs should be respected. Unity in diversity. Implementation is not easy on a ground level. Fair enough. Ethnicity violates freedom given in the constitution. Okay. Should not focus on uniformity, rather unity in diversity. Core religious beliefs may be bypassed. Fair enough. Okay. Not known. Very good. So the arguments are largely in favor of two things, or arguments against. Full form of UCC is Uniform Civil Code. This is UCC. Uniform Civil Code. Today is Sunday, right? Some IPL match is going on, I'm sure. So somebody is busy watching IPL also side by side. Anyway, so challenges. First challenge that everybody pointed out was diversity. Whether it is religious diversity, religion, or tribal. There is diversity. I mean, there is too much of diversity in the country to have uniformity. And because India claims to be a secular state, interference in personal matter should not be expected from the country or from the state. And this would be wrong. Then what is this song of secularism? And please understand the guarantee and promise we have given to all the people of Article 25, Article 26 said, don't worry, you are in India, you are free to practice your religion. Then framing a UCC. So this is a very big problem. How to frame UCC? And to tell you frankly, the biggest issue is this only. When people say, let's have UCC, the first question you should ask is, show me a UCC. At least show me a draft bill of UCC. I want to see what your UCC contains. Only then can I comment on it. Nobody is prepared to make a bill. And all these left-wing liberals upload videos. Yes, Lekha, I fully agreed on your point. So all these left-wing liberals, they always claim, right now they're also claiming, posting videos. We should have UCC for a tight slap on the face of right-wingers. And what slap will you plant on the face of right-wingers? What is your stupid logic to have UCC? How to create UCC? There are so many religions. How will you find the common ground? What neutral principles will you adopt that pacifies everybody? And what is going to happen is, let's say you make a UCC. Let's say, if the UCC is very close to the Hindu ethics and way of life, all the minorities will start saying, oh, look at the Hindu majority country. After all, minorities are suppressed. If you make the UCC, which is very close to, say, the Muslim or Christian way of life, all Hindus will say, oh, look at this minority appeasement, never stops only. You can never please everyone. Why to put your hand in this hornet's nest uselessly? Why to open this Pandora's box of troubles uselessly? Let it be. Right? Let sleeping dogs lie. There is no need to uselessly create a problem. And the very important thing is, there is complete lack of national consensus. And see, people say we have a common civil law, we have a common criminal law, let's have common personal law. That logic does not work. Civil law and criminal law has got nothing to do with religion. Religious matters are largely enmeshed or deeply enmeshed with culture and also with your personal matters of marriage and divorce. So people here who also believe in, say, they claim that I am agnostic, I am atheist, they would also want to, eventually marry with proper customs and traditions. And in India, as Loknath Mishra in the assembly had said, that religion can never be divorced from life. That's the beauty of this country. That even now, for those who don't believe in God at all, you will find it very awkward to step on a book with your foot. You will not do it. Or you will not enter a temple or a place of worship wearing shoes. It comes naturally to an Indian. Whether you're a Hindu or Muslim does not matter. So some things are very natural to people who are born in this country, right? That culture and ethics will never go away. That is what is the beauty of this country. That is why people of different religions, they have also imbibed those cultural aspects. You see how Muslims worship in India or how Christians worship in India. It's vastly different from what is the way of worship in Western countries. Because here, that is what works. So that's also there. Now, imagine a parliament which comprises of Hindus majority. Of course, we are referring to a country where 75% people are Hindus. If you randomly pick 75 people, 100 people, 75 will be Hindus only. So our parliament has majority of Hindus, so it is no surprise. It must be there. Proportional representation has to be there. It is there. But when they make laws, don't you think there will be a natural fear in the mind of minorities? Not because the MPs could be biased. Maybe they may feel, what understanding does a Hindu have of Muslim ethics? Or what understanding does a Muslim have of Christian ethics? What understanding does a Muslim have of Hindu ethics? So it's very problematic. And there will always be a fear in the minds of minorities of majority dominance. That is why, and the summary of this discussion is yet to see a UCC text. You firstly show me a text, and then we'll debate on it. Nobody wants to frame a UCC. Everybody wants UCC. Recently, also one MP gave notice for a bill, and what was his bill content? He said the government should frame a commission to form UCC. You want UCC? Form a bill. Let's see. Nobody wants to form a bill because framing the bill is the biggest challenge. Anyway, so how do we go about this issue? There is a problem. You have to agree on certain points, especially these 2 points. You have to agree on these 2 points that yes, religious laws do discriminate against certain communities, categories, genders, etc. The best thing, see, apart from all these laws, somebody was mentioning intercaste marriage. Intercaste is not a problem. You can get married under Hindu Marriage Act only. But what if you are a Muslim, you want to marry a Hindu, you are a Christian, want to marry a Parsi? Then what do? And let's say both of you don't want to convert also. If say I am a Muslim, I want to marry a Hindu, either I convert or the other person, she converts. But if we don't want to convert, then what do? There is a law called, and the first law made was this only, Special Marriage Act 1954. This is a religion neutral law. So all inter-religious marriages are conducted, solemnized under this only, registered under this only, in case both parties have no interest in leaving their religion or converting whatsoever. Let's do one thing. Why don't you promote Special Marriage Act only? All the people sitting here, in future, once you get married, why don't you at least take the responsibility of getting your marriage? Even if you're a Hindu marrying a Hindu, no problem. I will not get registered in the Hindu Marriage Act. Even if you're a Muslim marrying a Muslim, I will not get registered under the Muslim Marriage Act. I will choose Special Marriage Act. Why can't we promote it? And the bigger issue is eliminating any kind of practice which is derogatory to a group. Like say triple talaq was wrong. So if you are having some throat infection, you won't cut your throat away, right? If your hand is paining, you won't chop off your hand only. Very simple logic. If a religious law has some problem, some provision is wrong, rather than throwing the entire religion away or religious law away, why don't we selectively weed out those practices which are derogatory to any individual or any group? Okay. Why can't we selectively remove that? Why do we have to throw the baby with the water? Do that. Then raise awareness. Raise awareness on the importance of a neutral law and promote Special Marriage Act. Run campaigns, awareness campaigns, have discussions on social media platforms on the advantages of SMA or other laws. What benefits? See, if I want to join Special Marriage Act, what are the ethical benefits? What are other kind of benefits that I will be getting if I get my marriage registered under SMA? I should know, right? We should tell people. So if you focus on that, then it will be better to rather than coercing people, persuade them softly. And that is why I say coercion and democracy don't go together. And eventually, if you still say, no, sir, I want UCC, let's do one thing. Let's make a UCC and let's keep it optional. Optional. If you want to join UCC, join. If you want to follow your own personal law, follow it. When more and more people join UCC, automatically the religious laws will lose their relevance and significance. It will happen automatically. You would not need to go to people and say, come on, UCC. No. Coercion and democracy never go hand in hand. Always understand. Uh, I find that there is a very serious issue in general amongst people, though it is surprising to find that not in this class, that the youth is getting way more, no, I would say, very adamant and dogmatic in their approach that my way is the best way. No, that is not correct. You have to also give space to the other community and other people on their opinion. And for you, it is more important because you will be holding a very important post in future. Others don't really matter, frankly. It may sound very elitist, but others don't matter. They will follow what you do. You will have the wielding power to make people follow what you do. So what you think matters. And that is what matters to me. But what you think, because you are the future generation who is going to be in the position of authority. So that is what is very important. So give space to others. And we are always focusing on homogenization, unity, uniformity. We say unity comes with uniformity only. No, no. Why do we have our aim of uniformity? Why not unity being our aim? And we attain unity only through variety. Differences have to be integrated. Differences need not be absorbed and annihilated. We have to celebrate our differences, right? Because, frankly, it is never our differences which divide us. It is our inability to recognize those differences, to accept them, and to celebrate them that divides us. And as far as our country is concerned, what divides us pales in comparison to what unites us. And that is why the focus has to be on reform, not homogenization. The first 2 points are focusing on reform, not homogenization. Okay, that should be your pros, cons, and way forward, ideally. You, Subhash, how can we promote social media, campaigns, telling people how do you spread awareness on any kind of topic? Same thing. If I want to promote by my marriage, how it should be done? For that, you should firstly study all other laws. That nobody will do. If I want to showcase the advantage of Special Marriage Act, I have to study all laws, draw a comparison, find out what is the problem in every other law, what this law offers in a better perspective, and then present that to people. Podcasts, go to shows, visit them, write articles, make videos. Avni, what is ethical? That you have to find out what is the ethical perspective. For example, you are claiming that other laws, are biased against women. That's the ethical perspective. You can tell this to any man that, see, if you are choosing a Muslim law or a Hindu law or a Christian law, you are choosing patriarchy. Choose SMA and you're choosing equality. The choice is yours. That is ethical dilemma, right? So these are things that we have to find out. What is Special Marriage Act? A Special Marriage Act is just a law which regulates marriage in the country. So Special Marriage Act is just like Hindu Marriage Act, Muslim Marriage Act, all these things. We don't need to do a research on the provisions. In case you want to download the PDF and study to your heart's content, what is a provision there? See, there are some basic differences. For example, differences in who you can marry and all. Like, say, uh, amongst Muslims, marrying cousins is allowed. Amongst Hindus, especially in South India, you can marry your uncle also. So you can marry your mother's brother in South. It is allowed in various places. So this is there. Basic differences. For example, in Christian Marriage Act, you have to give 2 months prior notice to get married to your local church. So these are small, minute differences which are there between the SMA and other religious laws. It is beyond our scope of discussion. Okay. Jyoti, what about love jihad problem? We love jihad problem. See, we have to collect firstly data on love jihad problem. What is the scale of love jihad? Does it actually exist or not? So a lot of things need to be addressed first. We can't base our opinion on few YouTube videos and shorts. So we have to look into quantifiable data, right? We cannot simply act randomly. That I heard some case. Uh, what percentage? Is it like a very small number, or is it at a grand scale? So we have to look into all these elements also, right? And then come up with a solution. If there is a problem, we have to have a solution. But firstly, find out whether there is a problem or not, and what is the scale of it. In a population of 141 crore people, we can't say 34 cases are there. That is of no concern to us. There are 5 lakh people in jail, or 5.5 lakh people in jail. There are so many criminals roaming around. So in a country, 0.1% people will be completely criminal mind based. So we cannot, we can do nothing about it. It's okay. That's it. Moving on to Article 45. We have already seen Article 45 just today. What is Article 45? It is the right to education that was made under Article 21A. But originally it was Article 45. Provision for early childhood care and education to children below the age of 6 years. The state shall endeavor to provide ECCE for all children until they complete the age of 6 years. We have seen this provision today only. Then 46, again, promotion of educational and economic interest of SCs and STs and other weaker sections. The state shall promote with special care the educational and economic interests of the weaker sections of the people, in particular scheduled caste, scheduled tribes. Of course, we know that they should be protected from social injustice and exploitation. For that, what do we have? The entire gamut of affirmative actions that we have in the country are for what? For this only. Or we also have bodies like NCSC, NCST, etc. for this only. Then 47, duty of the state to raise the level of nutrition and the standard of living and to improve public health. So the state shall regard the raising of level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties. So what's the primary duty of the state? Improving the public health. So vague. What is public health? Should we all have muscles of 16 inches now, or six-pack abs? Imagine if this is justiciable. You go to court and say, court, come on, ask the government to give me protein powder. I want to build 18-inch biceps. So a very generic, vague kind of thing that, we want to improve public health in general. Okay. And in particular, the state shall endeavor to bring about prohibition. So this is the liquor ban article of consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. It is this provision which bans, or which allows the states to ban liquor. Okay, so liquor ban is there in states like Bihar, Gujarat, Mizoram, Nagaland, Lakshadweep, some districts of Manipur. So these are areas where we have liquor ban. And see, even if you look at the legal drinking age, it's very confusing in the country. In most countries, it's 21. But if you go to, say, Meghalaya, Punjab, Delhi, there the legal drinking age is 25. I mean, you can vote at 18, marry at 21, can't drink till 25. It makes no sense. If you go to Himachal, Goa, Karnataka, Sikkim, Pondicherry, it's 18. So these things are there. I'm not promoting reducing the drinking age. I'm simply saying, pointing out the silly follies that we have with respect to dealing with people. Then Article 48, this is the beef ban article, Gandhian principle, of course. The state shall endeavor to organize, and just to point this out, Article 47, I mean, whether drinking, see, drinking or not drinking is more of a moral or ethical dilemma. And frankly, to each his own. It is not that people who drink are criminals and who don't drink are the best human beings on the planet. There is no such criteria. Alcoholism is a problem. but a casual drinker may not or may have very high moral values. Why do we have this kind of principle in our constitution, which is a moral kind of principle? Makes no sense. These are what make you realize that DPSPs are very poorly framed. They are like some UPSC aspirant is writing some essay and randomly collecting some ideas and joining them in one DPSP. We are referring to a legal document. The legal aspect is involved. Economic, social angle. What is this moralistic angle involved here? But anyway, that's we had to incorporate Gandhian principle somehow. Then Article 48. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch. Milch means what? Milk producing. Milk producing which is fit for human consumption. Every animal is producing milk, but not tigers and lions, goats, cows, buffaloes, okay, camels, fit for human consumption. And draught cattle. Draught are the workforce cattle, beast of burden that you call them, like oxen, donkeys, horses, camels, etc. Right? These are the beasts of burden. So we should not kill them. We have to, ensure that we prohibit the slaughter of these people, these animals. Okay. Then 48A, protection and improvement of environment and safeguarding of forest and wildlife. The state shall endeavor to protect and improve the environment, safeguarding the wildlife, the forest. Simple. 49, protecting the monuments. So it is an obligation, it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest. It shall be the obligation of the state to protect every monument or place or object of artistic or historic interest. From what? From spoliation, from disfigurement, from destruction, from removal, from disposal, from export. And of course, it's also our duty not to go to these places and then write Raj Love Simran, draw a heart. We should not do it. Parth, reason behind banning liquor election time is that people remain in their conscious state to vote. That's the reason. The vote should not be purchased. People should not be losing their conscience to bribes, succumbing to drinking problem, and then voting randomly here and there. That is the only reason. Article 50, separation of judiciary from executive. What is this? Don't we have separate Supreme Court, High Court, and government? Of course. What nonsense is this? Article 50, separating judiciary from executive. This is for public service. So, a very sad piece of information for you. So, you know very well that for the large part of our post-independence situation, there has been a slow decline in the powers and respect and authority of our bureaucrats. How? See, earlier till 1973, be surprised, bureaucrats also had the power to punish people. Why are they still called magistrates? Because of power to punish. It was only in 1973 CRPC was made and DM will administer and we will have a concept of what? Judicial magistrate who will punish. So that's there. So this separation between the powers given to administrative authority and judicial authority. So that is why if you ask any person from the older generation, DMs used to be gods. There's a joke which goes that the PM is coming and people are saying it's okay. DM is not coming, right? No problem. So they don't care about PM, CM, anyone. They care about DM only because he was one who is wielding all the power. Now there is no beacon also. Beacon, BEACON. What is beacon? Red batti, the lal batti that you would show off. That's also gone. Let's see what else goes away. That is why clear the exam, enjoy some perks till it lasts. Okay. Finally, Article 51, promoting international peace and security. We are nice people, decent people. We don't fight. We solve problems through arbitration. That's our point. Don't fight. Peace. Discuss. So, the state shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international laws, foster respect for treaty obligations, and also encouraging the settlement of international disputes by arbitration. As I said, we are peace loving people. We don't fight. We don't want anybody to fight. Any problem, discuss, sort it out. Okay. Solve some questions quickly. Asked in 2020, a very difficult question. I'll give you 30 seconds. Let's not waste time. Mark the answer, please. Of course, it's a DPSP, separation of judiciary from executive. Which article is this? Article 50. This question, solve please. Done. 89% got this correct. International peace and security. Great. DPSP. Now, amendments to DPSP. So we have seen some A's attached here and there. So this has to be mugged up, please. DPSPs have been amended 4 times. One in 1976, the other in 1978, then in 2002, and then in 2011. 4 times. In 2011, this article was added. In 2002, this article was modified. In 1978, this article was modified, and in 1976, these three articles were added, and this was modified. Okay, these 4 changes, no explanation required. You have to mug up these. A question has been asked earlier from this topic. Okay, so please mug up all the 4 amendments and what articles were added in which amendment. This is going to be important, please. Okay. Solve this question. Came last year, year before last. Okay. In the Indian Constitution, concentration of wealth violates DPSP. What is this concept of welfare? Random answer. 39C. Okay. Solve one more question. Let's see. This was a question which was based on the amendment made in 1976. We've just seen it right now. It may be difficult for you to mark this correct. Let's see how many of you get it correct. Okay, very few. No problem. Let's see 1976 amendment. Article 39, secure opportunities. 39A, free legal aid. 43A, participation of workers in the management of industries. 48A, improving the environment. Let's come here now. Equal pay, not really. Participation of workers in the management of industries. Okay, this was the one which was correct. So far, all the answers of DPSP have been B only. Do you observe this? B, B, P, P. So, very weird coincidence. Anyway, answer this question. Okay. Again, the answer is B. Welfare state, TPSP. Solve one more question. Came in 20. And look at the question here. 2015, they ask, the ideal of welfare state in the constitution is enshrined where? Right? 5 years later, which part of the constitution declares welfare state? They are just changing active, passive and asking the exact same questions. And of course, they have changed the options also. Let's hope that this time I see 99% correct answers. Oh, 98%. Almost there. Almost there. Great. And also an answer which is not P in DPSPs. Now, coming to why are DPSPs not justiciable? Of course, financial issues. We are saying improve public health, right? We are saying that nobody should work forcefully, give employment allowance to everybody. So the biggest problem is the administrative constraint on how to implement these things and the economic problem, financial constraint. Then some are moral in nature, enjoyment of leisure period. I mean, how do you ensure that? Then inadequacy of social and economic development also. That's also a challenge. Inequalities will always exist in the country amongst people. Treatment different will exist amongst people. For example, panchayats only. Why did we take 42 years to implement panchayats? Because in 1950s, if we had implemented the provision of panchayats effectively, it would only mean that you are giving all the power to the rich and wealthy landlords in the village. So the rural economy had to go through a change, and then slowly we found the time to be ripe to devolve more powers to panchayats and municipalities. So these things are there. Then, nature of DPSP. So just to summarize, DPSP Article 37, they are fundamental principles. Yes or no? Of course. They are non-justiciable. We can't go to court. And they are non-self-executory. I mean, you can't enjoy them on your own. Government has to take some steps. Meaning, laws must be made to enjoy DPSPs. Now, fundamental rights versus DPSPs. So, there is no conflict as such between part 3 and part 4. They supplement and complement each other. This is Supreme Court statement in Minerva Mills case. Supreme Court says that the beauty of DPSP and rights are that they supplement, they complement each other. They are together called the conscience of the Constitution, right? And that is why, but yes, never forget, Article 39 B and C, they are given a higher position than Article 14 and 19. So please, this needs to be understood and needs to be respected. So what I also mean to say here is this point that DPSPs can actually be a source of restriction on rights in pursuit of public interest. Because if we are looking for larger economic welfare of poorer people, then it can act as a restriction on fundamental rights also. So your rights may be restricted, may be violated sometimes, 1419, if the larger perspective of making the policy or law is for benefit of everybody. That's it. Then the criticism. So DPSPs are non-justiciable, of course. So people say, then what's the point? You have to depend on the government forever. Depend on government. Number two, so we had seen Article 37 that it shall be the duty of the state to incorporate these principles. What kind of duty? Is it some kind of legal duty that if the state does not perform, we'll punish them? Or is it just a moral duty? So that is also a very critical question which is ambiguous, left unanswered, confusing. What is it? Not clear. Lack of clarity. Same thing again and again. Repetitions. Unsystematic enumeration. You have right to work, suddenly UCC, suddenly cottage industries, suddenly legal aid, then suddenly protect animals, don't drink, don't kill animals. So the order is not a very smooth transition from one topic to another. It's like random good moral science topics are put here and we say nice things. That's also a problem. Then it combines modern rational principles, protect the wildlife, international peace, security, etc., with those based on sentiment. Uh, don't drink too much. Let the people enjoy their leisure period. What is this? Sentimental argument. This is a legal document. It has no place for these sentimental things. And lastly, some recommendations are concrete, like they use a word. In particular, every article you'll find has two parts. One part, the opening part is very generic. Second part, very particular. So that's it. These are some of the criticisms of DPSP. That's it. We are done with the directive principles of state policy. And before we end, you know very well, Article 335, we have seen this yesterday only, that the claims of SCs, STs to services will be taken into consideration, but without compromising on the efficiency of administration. Number two, we have seen this also under center-state relations. What is this? This says that we will have to ensure that the state takes proper steps, or the states and the local bodies take steps to provide education to all the kids, at least till their primary stage, in their mother tongue for all the linguistic minority groups. And if it is not happening, then the president can issue binding orders for that. This was explained under center state relations. This is something we'll see maybe in the next 1 hour. Article 351. We are done with DPSPs. You can answer this question now. Very simple. Discuss the possible factors that inhibit India from enacting for its citizen a UCC as provided for in the DPSP. No problems here now. I hope this question can be addressed by you. Now, a very small topic, and then we'll take a break. Fundamental duties. It's a very small topic. This was not there originally. This was added in 1976 on the recommendation of Sardar Swarn Singh Committee. Okay, Part 4A, and only one article, 51A. This is what is fundamental duties, and we have drawn inspiration from USSR. Even though Japan in its constitution also has duties, but our inspiration has been Soviet Union. Achha, one simple question. What other provision in the constitution was added by, or was added on the recommendation of Sardar Swarn Singh Committee? Please write. What other provision in the constitution has been added by or added on the recommendation of Sardar Swarn Singh Committee? Please write. No idea. Not a single one person has answered, that is incorrect only. Not a single person knows this. How is it possible? Clearly, I'll have to explain. Tribunals. Tribunals were the provisions added. Part 14A, 1976, 42nd Amendment Act. Tribunals were added on the recommendation of Sardar Swarn Singh Committee. Okay, 10 duties originally, one more added later on. Which one? The duty of every citizen to send the kid to school, 11th duty. So we had originally 10, now 11th duty. So, and these duties are meant only for citizens, not for aliens, citizens only. It shall be duty of every citizen to abide by the Constitution and respect its ideals and institutions, the national flag and the anthem. Of course, very good. To cherish and follow noble ideals that inspired the national struggle for freedom. What noble ideals? Non-cooperation, civil disobedience. Should you follow them now? Don't obey rules, break the laws? What is this? What kind of duty is this? This is some moralistic kind of duty. It's not some genuine civic duty. It's a very moralistic duty that follow those grand noble ideals that inspired the struggle for freedom. But the struggle for freedom was against a foreign body. You can't use the same things against our own elected government. It makes no sense. Number 3, this is clause A, this is clause B, this is clause C. To uphold and protect the sovereignty, unity and integrity of India, of course, without doubt. Then clause D, to defend the country and to render national service when called upon to do so. Okay, civic duty, very good. E, to promote harmony and the spirit of common brotherhood amongst all the people of India. Oh, so nice. Transcending, crossing religion, language, region, section, and to renounce practices derogatory to the dignity of women. Again, a moralistic kind of guideline. What is the legal argument here? practicing brotherhood. What do? Send good morning text to everyone on the in our country. Again, very generalist kind of argument here. Then, to value and preserve the rich heritage of our country's composite culture. Again, vague, abstract, makes no sense, that we have to value and preserve the rich cultural heritage of our country. Then, to protect and improve the natural environment, including forests, lakes, rivers, wildlife, having compassion for living creatures. These are very, very generic kind of things. Everybody does all these things here. Come on, you don't need to write this in some legal book to enforce it. Then, to develop scientific temper. Scientific temper, humanism, spirit of inquiry. It is my duty to develop scientific temper and inquiry. And Article 25 gives us the right to freedom of religion. But religion says don't ask questions. If I follow my duty too nicely, people will thrash me properly, saying, oh, asking questions, religion, questioning God only. See, conflict. So you are expected to question, but if you question too much, problems can be raised. Then, to safeguard public property and to abjure violence. Okay, safeguarding public property, thinking of public property as your own. No, not personally as your own. Don't take it home, right? But safeguarding public property. Then, look at this duty. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. What is this? This is a motivational speech given by somebody to one's kid, that please study. If you study, you will improve your life, have a better quality life. What is this striving towards excellence? How do you achieve this? What is the parameter? What is excellence? It's a very abstract term. These duties are very bogus. Most of them. They are being followed any which way by people. Makes no sense. Then, to provide for education for kids 6 to 14. This was the one which was added when? 86th Amendment Act 2002. And the critique, very simple. Vague words. What is this? Striving towards excellence, right? Then preserving the heritage of our country's composite culture. Spirit of common brotherhood amongst all the people, transcending religions, etc. J repeat. Arey madam, it's right in front of you. I am just reading it out. Duty J means these are just so moral and abstract principles. What do I explain here? What do I explain? That you should put efforts to improve excellence in all spheres of individual personal activities in your life. Study well, get up in time in the morning, right? Perform all the chores properly in your house, help your parents, go out on the road, keep the roads clean, collective activity, follow the traffic rules properly, so that nation constantly rises to higher levels of endeavor and achievement. This is explanation. What to explain here? Anyway, so that's there. So vague words, you can see very well. And most of them can't be enforced. How do you enforce this? I just explained the duty J. How do you enforce this point that we have to strive towards excellence? Should we go to everyone's house, ask them, come on, don't watch Netflix, study? We can't enforce it. And citizens perform these duties even without state's coercion. So these duties made no sense absolutely. And we already had all these laws in the country there which legally enforce some of these duties. These duties are not legally enforceable, by the way. Okay, this matter is pending in the court right now. Enforcement of fundamental duties, Durga Dutt case is pending in the court in front of 3-judge bench. But there are other laws in the country which enforce some of these things. For example, there is a duty to respect the national ideals, right? There is a law. The law is called Prevention of Insult to National Honors Act. makes it a punishable offense if you create any obstruction in the demonstration or performance of national anthem. So these are there, all these laws. That is all as far as our duties are concerned. And sadly, it's again a topic which was best left not added in the constitution. And had we added this, we should have added duties like duty to vote in the elections, duty to pay taxes. That would have made more sense than these kind of abstract duties. It's more like, ask not what the country can do for you, but what you can do for the country. In that sense only. Anyway, solve one question quickly. Oh, sorry. Poll. %54% have marked this. Rights are correlative with duties. Okay, absolutely correct. Rights are personal and hence independent. I had just explained a couple of hours back, like say your speech and expression. It is not independent of society. You can't use your expression to defame somebody. That's wrong. Rights, not duties, are important. Why? Both are important. Duties, not rights, are important. Again, both are important. Solve one second last question. Shalu, what is benefit? There is no benefit. There is no benefit whatsoever. There is no scheme, no program being run specifically for them. The only benefit is that if you as a minority are facing any dispute, any problem, then please approach NCM and get your dispute resolved. Get your issue addressed. That's the only benefit. There is no other benefit. No scheme or program being run only for their benefit. No special scholarship, nothing. It is just an obsession to get a tag of that. There is no benefit right now. Okay, great. Some of you mark D, but actually, this is not a duty. Think of it. To protect the weaker sections from social injustice is not mentioned in the duty under Indian Constitution. So 2 is wrong. This, this, this. C is the right answer. Preserving the rich heritage, of course. Scientific temper, of course. Strive towards excellence, of course. Last question. Solve this. 30 seconds. Okay, 78% marked A. Under the Constitution of India, which of one of the following is not a fundamental duty? To vote is not a fundamental duty. Sadly, this is the only duty which, this is by far the most important duty, and that is not a part of the duties. Others which are less important are part of duties. Anyway, so A is the right answer. That's it. We'll take a break now. We'll be back at 5:35 and we'll continue our discussion further. Oh, some people want the leaderboard. Maybe all of you have marked all the answers correctly. So, Saikat Ghosh and Yash, 120 points, 12 questions correct, I believe. All toppers today. Then, with 11 correct, Anshita Mishra, Ravi Kumar, and Shalu. Then 10 correct, Dhaval, Ratnasari, Uday, Priyanka, Sivasubramaniam, Subhash, Kajal, Shweta, Sandhya. Then with 9 correct, Dilip, Sakshi, Lekha, Sudhanshu, Namita, Pallavi, Kshitij, Jayabardhan, etc. So this is the case. Haji, Yash and Saikat Ghosh. Very good. Yes, all stars, heart emojis. Great, great. Amazing, amazing. Very good. Yeah. Let's take a break. Be back at 5:35 and then we'll continue with our last session for the day. Okay? Break, please.